Good afternoon, everybody. It's 2:30 in London. We are just watching participants enter the webinar, so we will wait for a moment or two before we start. Okay, well, good afternoon, everybody. A few people still entering the room, but I will start with the admin and so on to get us moving. My name is Tom Keating. I'm director of RUSI's Center for Financial Crime and Security Studies, and it's my great pleasure to chair today's webinar. I think we're all used to this now, but before we get started, do just have a read of the instructions on the screen, the housekeeping points. Please note that the full webinar, including the Q&A, is being recorded. If you want to ask a question, please pose it in writing in the Q&A box and do include your name and organizational affiliation, just so we have an idea of where you're coming from. And in true democratic style, we will use the upvote function. So if you see a question you particularly want to have asked, then do click the thumbs up. Most of you will be familiar with the Center for Financial Crime and Security Studies at RUSI. Those of you who aren't, we're a specialist research program at RUSI in London, although I join you today from our office in Brussels at RUSI Europe for our first international trip for some time. Lots to talk about in Brussels at the moment on enablers and other things. But we look at matters at the intersection of finance and security. We, of course, also look to convene the right cross-section of brains to consider the challenges posed by finance and security. And I hope you'll agree we have done that again today. So the genesis of today's webinar, as part of an initiative we are running at RUSI that we call the Transatlantic Response to Illicit Finance Tariff, we've set up a task force to engage with the ways in which the US and the UK can take more active responsibility for driving forward the global response to illicit finance. We had our first task force meeting in July. The next one's scheduled for November, and we're disseminating the ideas that are produced by our task force in writings and via our own podcasts, and taking part in those of others like Nate Sibley's at the Hudson Institute. Now, the first meeting focused on getting our own houses in order. So we were considering the domestic policy actions that have international implications that will serve as an essential first step in leading the global fight against illicit finance. So, for example, by bringing forward the overdue reforms to Companies House, something which has been highlighted this week by the Pandora Papers, the UK isn't only going to strengthen the integrity of its domestic financial system, but it will also benefit those countries around the world where the economies suffer as a result of the ability of kleptocrats, the corrupt and organized crime groups, to hide their wealth via companies established in the UK. Another area that deserves scrutiny in this regard is the grouping of professional service providers, often referred to as enablers, the topic of today's discussion, and what I think I would consider to be a heterogeneous group that represents an Achilles heel in the fight against illicit finance. And while a lot of focus has been placed on those that move and invest the proceeds of illicit finance around the world, so by that, of course, I mean the bankers, we, of course, need to focus on the facilitators that are needed to arrange these transactions, the gatekeepers, as some call them. They have far less scrutiny. And again, the recent release of the Pandora Papers, I think, underlines this vulnerability. And we're not just talking about accountants and lawyers and company formation agents and real estate executives, but increasingly we see PR agents and defamation lawyers offering tools that are required by those seeking to launder their reputations and create a pretense of legitimacy in the global capitals where they're seeking to spend and enjoy their wealth. So this discussion then will consider how London and Washington can make a step change in combating these facilitators. So to talk about all this today and to discuss this critical element in the transatlantic response to illicit finance, I'm delighted to welcome a transatlantic cast. First, we have Dr. Katie Benson, who's a lecturer in criminology at the University of Manchester, and also, we're pleased to say, an associate fellow of our program at RUSI. She has spent at least a decade looking at the issue of enablers, both from an operational and an academic perspective. Secondly, we're joined by our friend from Washington, Josh Rudolph, still with the greatest job title in the world, fellow for malign finance at the Alliance for Securing Democracy at the General Marshall Fund, who's just published a paper timely on enablers and can give us the highlights of that. We're joined by Moira Rusin, a professor of financial crime intelligence from the Middlebury Institute in Monterey, California. We will watch the sun rise behind her as we progress through the webinar. Moira, thank you very much for joining us so early in the morning. And lastly, but certainly not least, we're joined by Franz Wild from the Bureau of Investigative Journalism, where he runs a project that is conveniently entitled Enablers. So we have definitely the right experts in the room, but of course, we would welcome, as ever, your thoughts, your comments, and your questions as participants in today's webinar. So do please make use of the Q&A box and its upvote function, and we will do our best to cover as many of your questions and thoughts as we possibly can. So with that, I will now pass the floor to Katie, who can kick us off. Katie, welcome, and over to you.
Thanks very much, Tom. It's really lovely to be here for this event. So yeah, as you mentioned, I first became interested in this issue of enablers about 10 or 11 years ago. At the time, I was working in UK organised crime policing, and this idea of professional enablers, this concept of professional enablers was just really starting to take hold in organised crime policing and policy discourse in the UK. And the basic idea was that it was no good for us just to be focusing on the primary offenders, those people at the core of organised crime activity that had been the traditional focus. We also needed to be thinking about those individuals who had primarily or ostensibly legitimate occupational roles, but who in some way facilitated organised crime activity. And one of the key ways that they did this was by facilitating money laundering, was by enabling the financial aspects of organised crime activity. So when I moved into academia, I started focusing in on the legal profession, and so the role of lawyers in enabling money laundering and illicit finance more widely, and the criminal justice and regulatory responses to this. And so this is the area that I've written primarily about. I think because mainly I think for various reasons, this is a particularly interesting and particularly complex sector in relation to their role in enabling money laundering and their anti-money laundering supervision. And I know this is something Josh has talked about when I've heard him talk previously on the subject. And I think that it's important on the one hand to think about the different sectors individually, because they each have particular contexts and particular challenges. But I also think it's important to think about the processes of money laundering, illicit finance, corruption, organised crime, etc., and understand how different actors play certain roles at different stages of the process and the reasons for this. And there was a really good report by Ben Cowdock and others at TI that looked at this. It looked at it in this way a few years ago. So obviously over the last couple of decades, I would say this issue has grown on national and international agendas to varying extents in different places. So it was first highlighted really at a G8 conference on transnational organised crime in 1999. And since then, we've seen the FATF extend customer due diligence and reporting obligations from banks to non-financial businesses and professions. At the regional level, in the EU context, we've seen the money laundering directives evolve over the years to bring designated non-financial businesses and professions into anti-money laundering requirements. And then individual nation states have incorporated those kind of global or regional standards to greater or lesser extents into national legislation. And globally, different countries have varied in the extent that they've implemented the FATF standards in relation to this. So there's some level of harmonisation or standardisation within the EU, for example, but the UK and US are at pretty different stages of this. Other countries similarly as well. I've done some work in Canada with the Cullen Commission on Money Laundering in British Columbia. And again, like the US, there are some particular issues in relation to anti-money laundering obligations for lawyers in Canada that they're trying to deal with. And it's important, I think, to remember that you can't just transplant policy from one country to another. Everywhere has a kind of a local context that will shape how global standards are experienced and can be implemented in a local context. But everybody's continuing to try and move forward and deal with this issue, I guess, to various varying extents. It's increasingly high profile, and now there's become much more of a focus on high-end money laundering, on the proceeds of corruption, kleptocracy, and the harm that causes, because obviously of things like the Panama Paradise and Pandora Papers. So we'll hear about the moves that are hopefully being made in the US. The EU, again, are making further anti-money laundering changes, primarily probably in relation to banks, but non-bank enablers are also on the agenda. And so they should be, you know, for anyone interested in preventing or reducing money laundering and initial illicit financial flows. And there has to be attention on the individuals, organisations and processes that enable it. So solutions, and thinking about kind of solutions, or perhaps that's a bit too optimistic, ways forward perhaps with this. So there needs to be a combination of approaches. There needs, first of all, to be the legislation and the regulations in place that you want people to comply with. I think we broadly have this in the UK. There could always be changes and improvements that could be made. An organisational or corporate offence of failure to prevent money laundering will be helpful, I think. But we have the money laundering regulations. Again, there were questions about the sectors that covers and different things, but we have the money laundering regulations. We have the Proceeds of Crime Act, which allows for criminal prosecution just for a failure to disclose knowledge or suspicion of money laundering if you work in one of the regulated sectors. And also, of course, for those sectors that are professions, there are professional standards, rules and codes of conduct as well. You know, enabling money laundering tends to go against professional rules and codes of conduct, never mind being a criminal offence. So the framework is broadly there in the UK. You then need cooperative strategies to aid and encourage compliance. So there needs to be adequate and up-to-date education, training and guidance on anti-money laundering regulations and obligations. The availability of this training and guidance needs to take account of the capacities of different organisations to access it. You need clear and easy to apply rules that specifically address behaviours that might enable laundering. You need ways of highlighting the professional financial consequences of non-compliance. And I think you need to try and ensure that the regulations and obligations have legitimacy within the sector. And there's a whole range of strategies to support compliance based in our wider understanding from compliance research that can be applied here that I won't go into, obviously, in detail. But obviously also you need meaningful and appropriate enforcement of the criminal laws, regulations and professional standards when they've been breached. It's no point having the framework if that's not then going to be enforced. And there are a variety of things that can help achieve that at different levels to increase detection and then to ensure effective investigation, successful and appropriate prosecution and appropriate sanctioning. And I think fundamentally holding enablers to account through criminal justice or regulatory processes requires resources, political will, prioritisation and cooperation. And I think we're struggling with a couple of those in the UK at the moment. And then finally, and I promised Tom, this is my final point, but I think it's an important one. Finally, you need to think about how to inhibit the structural factors that provide opportunities for enablers to enable money laundering or make them vulnerable to being exploited for these purposes. So don't just think about this in relation to the people. You need to think about the structures that create opportunities and vulnerabilities. And a couple of examples of that are, firstly, for example, lawyers' client accounts or trust accounts, as they're known in the US and other places, can be considered an area of risk. And that doesn't mean we should get rid of client accounts, obviously, because they serve a legitimate purpose, but we can ask how we can reduce their vulnerability to exploitation, greater oversight of their use within firms, for example. And then obviously the use of shell companies and other corporate structures, trusts, investment funds, etc., is something that's on everyone's radars, particularly this week. And again, thinking about ways to reduce their ability to be exploited is important. So the push is towards greater transparency, proper registers of property ownership, reforming Companies House, etc., are all examples of this. And that kind of takes me back to what I said about the importance of political will, or the lack of political will being an issue. Okay.
Katie, thank you very much. I did want to just perhaps ask one follow-up question, because you touched on enforcement and then I also think supervision. We have in the UK, I think just in the last couple of weeks, the latest report from OPBAS, which for those that aren't familiar is the Supervisor of Supervisors in the UK. Basically, many of the enablers are supervised by professional service bodies as opposed to statutory bodies like the Financial Conduct Authority. And so they have an overseeing supervisor. I wonder whether you have a view on how that journey is going, because that obviously plays a pivotal part in ensuring that enablers are adhering to the regulations and the legislation that you laid out as an important part of the framework that, yeah, we probably do have right in the UK already.
Yeah, and that's really important. The supervision is obviously important. We need supervisors to be able to identify when this is happening, and then we need them to be able to take the kinds of actions that would hopefully deter enabling from happening. And you have this kind of whole scope of supervision. Anti-money laundering supervision under the money laundering regulations is done by the professional bodies, like you say, and the regulators. So for lawyers, the professional and the regulatory functions were separated. So the Law Society and the Solicitors Regulation are separated. But for lots of other professions, that's not the case. So it's the professional bodies that do it. And again, like you said, for accountants, I can't remember how many there are, but there are a number of different professional bodies doing the anti-money laundering supervision just for accountants. So we have this whole spectrum, and obviously there's not going to be the same kind or same quality of supervision across the board, which is why OPBAS came in to try and kind of harmonise that and make that kind of better across the board. And as we've seen from the reports about what OPBAS have done and what OPBAS have found over the last couple of years, there are still problems. I think we're making moves forward, and in terms of the legal profession, the Solicitors Regulation Authority now has a specific anti-money laundering team within it, which is a big step, and they're really focused on this issue, although they're only a small team, and there are lots of law firms in the country, and there are lots of so there's lots for them to be monitoring. So I think OPBAS gives us an opportunity to have a look at the different professional bodies and make sure they are doing the requirements that are expected around risk and managing risk and stuff like that. So it's a step forward.
Yes, better than we had, but perhaps more steps to take. Now, I think we've just said that the UK doesn't have a bad framework. I'm going to turn to Josh now, who perhaps is going to paint a slightly less positive picture, but I'm sure it'll be full of ideas as to how we turn the current picture more positive looking ahead. Josh, over to you.
Yes, let's go across the Atlantic and hear about what is a bad framework, but can be, and I think will be improved. And so let's talk about how to do that. I should say thanks for bringing together such a knowledgeable panel, Tom. I'm already learning a lot from Katie's remarks about different typologies exploited by different actors. This is particularly timely because we just it became public last night that the U.S. congressional response to the Pandora Papers is going to be a bill called the Enablers Act that will be introduced on Friday to impose anti-money laundering obligations on the professional enablers of corruption. The bill will mirror research that I am just about to present to you now. I'm sharing my screen. So hopefully you can see that. published this research two weeks ago. So again, good time to be discussing regulating the enablers. This research provides policy recommendations for the United States, both the executive and the legislative branches, mapping out a plan of regulatory attack. Because all too often, I mean, not here today with the helpful nuance that Katie laid out, but too often we rattle off all of these enabler professions in need of anti-money laundering rules, lawyers, accountants, real estate, without at least ranking them in priority based on an analysis in the United States of the US Treasury Department's capabilities and authorities. And so that kind of analysis is what this research aims to provide, going into some detail as to exactly what Treasury FinCEN should do to impose anti-money laundering obligations on 6 to 7 sectors of enablers over the next few years. There's, of course, also more for the rest of the U.S. government to do beyond treasuries, but my focus is limited to how to expand anti-money laundering rules to make U.S. non-bank enablers start looking for dirty money, and then we can get into sanctions and enforcement and sharing liability with the underlying perpetrators and all those kind of the broader whole of government approach to enablers. I also provide detailed recommendations about where the U.S. Congress that their action is needed. And again, now we're about to see that, particularly where Treasury does not have sufficient resources and authorities. But let me start where Treasury already does have all the information and power that it needs, with 3 sectors that the Biden administration should announce at the Summit for Democracy in December that they will be imposing anti-money laundering rules on these professions in the months ahead from there, so in 2022. First, the FBI warns that investment fund advisors are increasingly used by adversarial regimes to enrich beholden individuals, whether it's Russia dangling deals to hedge fund managers or the Saudis and Emiratis pouring billions into a private equity fund run by an alleged secret agent. So the U.S. Treasury Department needs to repropose a rule that it had drafted at the end of the Obama administration, but not before making 7 expansions that would also cover investment advisors who do not have to register with the SEC for various reasons, because there are smaller and more limited funds that are not relevant for, in the United States, the SEC's mandate of nationwide investor protection and market function, but they are certainly big and broad enough to serve as conduits for national security threats. For example, I surveyed over 100 cases of authoritarians funneling money into elections, and not a single case involved $100 million or more. So FinCEN cannot use those loose SEC registration parameters. Secondly, after investment fund advisors are real estate professionals, the most they have the most useful information about the, as I kind of display here, the crooks, mobsters, and oligarchs who secretly own U.S. properties. Now, to bring transparency to U.S. real estate, Treasury needs to make its geographic targeting orders, which make U.S. title insurance companies collect and report beneficial ownership data to the Treasury Department, make those obligations permanent, as you can see in the first row here, but then at the same time, expand the scope of those obligations to be nationwide for all price levels, including commercial real estate, identify sellers, not just buyers, and have a good definition of ownership. So that's real estate. That's the low-hanging fruit, the easy thing Treasury could do within a couple of months. And thirdly, Treasury could regulate art dealers. This is something that the EU did recently with its latest anti-money laundering directive, because when Russia invaded Ukraine and the US sanctioned Kremlin cronies, the world's largest auction house plotted to help the Russians evade the new sanctions by selling them art on the ground in Moscow, as an example. Treasury is already statutorily required to write a study of the art market by December 27th. Another reason why this is kind of at the top of the agenda. They're already working on analyzing this sector anyway. So And they're also required by statute to write regulations for the antiquities market. So they should write both of those, the art market study and the antiquities regs, to focus on money laundering through pieces worth more than $10,000, which would match the EU levels, but then also cover the full range of dealers, advisors, consultants, free ports, galleries, auction houses, museums, make them establish anti-money laundering compliance programs. I don't have it in this slide, but this is also relevant from what we were continuing to learn from the Pandora Papers yesterday. The art dealer selling looted Cambodian antiquities. The U.S. government stopped him from selling through Sotheby's, so you need the auction houses. Some of those pieces are still on display at the Met, so you need the museums. That's the art dealer. So those are kind of the three first low-hanging fruit. But stepping back, as we kind of started with, like, speaking of a bad framework, the United States is among the less than 10% of countries that are non-compliant with FATF recommendation 22. Don't make non-bank enablers, watch out for dirty money. One of just 11 nations who are non-compliant with the international standard. Part of the problem is that FinCEN, the bureau within the Treasury Department that's responsible for this, is severely underfunded, running on antiquated computer systems in a Virginia office building known as the Toilet Bowl. They need a bigger budget. But then in terms of how to allocate resources, as I mentioned, nobody has sorted out all of the legal, political, and practical considerations around which enabler sectors Treasury should prioritize first, second, third. And until now, nobody has recommended how to stage a regulatory expansion from now through the end of Biden's 4-year term. So again, at the Summit for Democracy in December, there should be a side event on financial transparency where Treasury should announce that in 2022, it'll impose anti-money laundering rules on private investment funds, real estate title insurers, and art dealers, because those are the three lowest hanging fruit. Now, in terms of where Congress can pick up from there, as I mentioned, we got the news last night that they're going to introduce on Friday the Enablers Act to cover the full range of professionals. It would bring us entirely into FATF compliance, and then have like one more area of sort of a cherry on top to a new best practice around PR firms, which we can talk about in a minute. But by coming into FATF compliance, that will require handling what I call here the four horsemen. And Congress is needed here because the Treasury Department has some catch-all authorities that it could use with the right determinations, but it would be much easier if Congress were to just name them, add them into the statute, among other reasons, because the horsemen are organized as politically powerful interest groups, and so regulating them will require really broad political support in DC, ideally expressed through legislation like the one that'll be introduced on Friday. So going through the four, first, legal professionals are the single most important enabler sector to regulate because they're the most useful to oligarchs and kleptocrats looking to secretly funnel dirty money through law firms' bank accounts. Katie mentioned trust accounts in the United States, sometimes called IOLTAs or attorney-client accounts. There's the Joe Low example of that one. We got more cases, lawyer cases out of the Pandora Papers this week. Now, particularly in the United States, lawyers are also the most obstinate and organized group in their resistance to AML rules. The American Bar Association has spent a quarter century in this war of attrition with the FATF, as you can see here. So the legislative strategy, very carefully scoping the statutory language, as this bill will do on Friday, will be important, and has to be accompanied by political strategies to divide and conquer the ABA, the way in the United States we did with our Chamber of Commerce during our initiative for beneficial ownership reform. So I have to learn some lessons there because that'll be a tough one. The second horseman is company formation agents, or more broadly, trust and company service providers, which in the United States are the worst in the world, or second worst in the world after Kenya in terms of their willingness to incorporate anonymous entities without asking for any form of identification. And third are our accountants, the ultimate keepers of secrets when it comes to large and sophisticated criminal enterprises. The most detailed example we have, although there were more in the Pandora Papers, I could say that for all of these enablers. But the most detailed example is the klepto empire of Isabel dos Santos in Angola, because the only honest job that she ever had was straight out of college as an accountant at a firm that later became PwC. So she really knew how to retain the most talented and pliant accountants in the world to cook the books, audit the same books, advise on corrupt restructurings, even going so far as having their PwC consultants help draft self-dealing presidential decrees that made her Africa's richest woman. So accountants are the third and final sector to be added to the Bank Secrecy Act. And that's, as much as Congress would need to do to bring the United States into compliance with the FATF's international standards. Because as far as the FATF is concerned, regulating these enablers is, just as important as beneficial ownership reform. In the United States, it's the second half of the battle to stop America from being the world's biggest offshore haven. Now, that being said, like I said, there's one more horseman that's not, it's sort of newer on the scene. And so I don't think the FATF standards have caught up, and that's covert PR and marketing firms. I say covert, meaning that they offer their clients and their money deniability, sort of like black ops. This is how Russia is laundering its disinformation about how the AstraZeneca vaccine will turn you into a monkey. The Pfizer vaccine is lethal. All of these lies that they pay influencers to promote without any kind of attribution, funneling everything through these fly-by-night PR firms, including some set up in London, that ultimately tie back to secret funders in Moscow who provide the same talking points as the Russian government uses to promote its own vaccine. Beyond that one case, there's an entire industry of disinfo for hire that has been exploding over the past 3 years, to the point that Facebook no longer even knows who's behind 36% and counting of the disinformation that they take down, because their investigations hit dead ends in the form of PR and marketing firms with secret clients. So if Congress were to make all of these firms establish anti-money laundering rules, which is what would be done in this new Enablers Act, and as is kind of laid out in the same way in the appendix of my research, it would be, as I said, the cherry on top of the most powerful policy campaign against dirty money in American history, frankly, equipping Treasury to hold its own in modern warfare against weaponized corruption, and showing how democracies can deliver against corrupt adversaries and powerful special interests. It'll be important to track how this legislative initiative goes, because if Congress does not pass legislation like the Enablers Act, Treasury cannot address the four horsemen, and these American professionals will continue to be the great enablers of kleptocracy. In that unfortunate situation, my research lays out how Treasury could instead spend the next couple of years on small ball, lower ambitions, repealing regulatory exemptions that are still important for some sectors that are already named in the Bank Secrecy Act. So please read the full report, but I really appreciate you listening, and look forward to a conversation.
Josh, thank you. Thanks very much. And yeah, thanks to those that are pushing forward in the US. I think, as you pointed out, the idea that the US still needs to achieve FATF compliance, I'm afraid to say, is a stain on the country. But perhaps to pick up that theme or other points from the US side, Moyara, we'll turn to you now, if we may.
Yes, thank you so much, Tom. And thank you very much, Josh, for that great summary of a fantastic report that I highly recommend all of our viewers take the time to read through. So you have clearly highlighted what should be our legislative priorities, but if anybody is following domestic US news lately, we have a dysfunctional legislature, and it's going to be very difficult to get much of anything done. trying to get funding for anything is like pulling teeth. The way that things have been done in the past is to sneak things into other larger bills. And that's exactly how the Anti-Money Laundering Act of 2020 was passed. It was part of a Defense Authorization Act. So that is one, strategy that we should keep in mind. I personally am somewhat pessimistic about this bill that's going to be proposed on Friday, only because it does include lawyers. And I just feel that is a no-go zone. It's just not going to happen, and it could sink it before there's any time for debate. So I think that what we need to think about when it comes to moving the needle in the right direction is the easy wins versus what's going to have the biggest impact. And those are unfortunately not the same thing. Well, with one possible exception, and that is the geographic targeting orders when it comes to real estate. I think that would be easy to implement nationwide. Right now, it only applies to a dozen large metropolitan areas. So there are a lot of regions to which it doesn't apply. It has a threshold, so it only applies to property sales over a certain amount, and it doesn't include commercial property. So we know that there are oligarchs who are purchasing vast swaths of commercial property in the Midwest where none of these geographic targeting orders apply. So that would be an easy win, and I think it would have a big impact. Just thinking about some of the other areas that Josh mentioned, I really do like the proposals for the December meeting, pushing private investment funds, title insurers, art dealers, as you say, low-hanging fruit. I think that could, go a long way. But the other problem we have is that the Corporate Transparency Act of the Anti-Money Laundering Act of 2020 does have a lot of loopholes in it. We need to close those loopholes. And perhaps, Josh, you're more familiar with, how the sausage gets made in Washington, D.C., of ways in which, we would go about trying to close some of those loopholes, like shelf companies, aged shell companies. I don't believe that they are included. And, there's some other big glaring loopholes. The other thing that we have to keep in mind too is when we have headwinds and tailwinds, and when there's a big event, we need to use that momentum to try to make things happen. And I would say that the mutual evaluation, FATF mutual evaluation of the US in 2016, that was a big event because we did get a bad report card. And, I wish we had been more embarrassed about it. Certainly, colleagues in Treasury were embarrassed, but also happy that it was now out publicly and they could use that to build momentum in shaping the Anti-Money Laundering Act of 2020, which I don't think would have happened had it not been for the bad marks that we got in that mutual evaluation report. And now that we have this, the Pandora Papers, just shining a big light on, South Dakota trusts, for example. Nobody was talking about South Dakota trusts before this week. Okay, we all knew about Delaware, Nevada, and Wyoming, but now that we have this big light highlighting this, I think that will build momentum for getting things done and helping to achieve some of the proposals that Josh has mentioned. So I'm going to stop right there to give Franz a chance to speak as well, and give our audience a chance to ask questions.
Well, thanks very much. Yes, I think it does highlight the power of the FATF. I think many of us are now watching the FATF with interest to see what the departure of David Lewis perhaps does to the energy that's been around the organization. And clearly we hope that FATF will keep driving reform forward on beneficial ownership and all these other issues that people look to it to lead on. But before we get into any of that, let's come back across the Atlantic and turn to Franz. Franz, over to you.
Yeah, thanks, Tom. My name's Franz Wild. I'm an editor at the Bureau of Investigative Journalism here in London. So the Bureau is a non-profit organization, and our business model is basically we invest in long-term investigations, and then we partner with other outlets to publish, be it the BBC here or the New York Times over in the US, or often kind of in several publications around the world or outlets around the world. And my project in particular focused exactly on professional enablers of international corruption, came into being a year ago. And I personally got involved in or interested in enablers, basically sort of from the back. I was a reporter a long time ago in the Democratic Republic of Congo for Bloomberg, and I was covering mining deals. And you kind of see all these strange things happening in the mining industry, and you kind of wonder what's going on. And the more you start writing about it, the more you realize it's not quite all what it seems, and there's a lot of corruption at play. And true enough, a lot of the deals I was writing about, ended up being investigated by the DOJ or the UK Serious Fraud Office. And the more I also looked into these deals, the more I ran into, lawyers and others who were trying to keep prying eyes away. So just to give you a very brief overview of what the Bureau Enablers Project has looked at. We've looked at, for example, money laundering at bank accounts at HSBC in Hong Kong. We've looked at suspicious funding of Russian origin companies here in the UK. And we've also looked at the role that British lawyers and private investigators play to kind of further the interests of autocratic states like Kazakhstan and Russia. And actually, I kind of want to deviate a little bit from the sort of strict illicit finance theme. And, and I think Tom and others have sort of touched on it, because it's much more than just money laundering, isn't it? It's basically, it's about making sure that once the money is laundered, these individuals are also able to establish themselves in largely in industrialized nations, and also avoid investigation or prosecution or whatever it may be. And that's where, in particular, lawyers are probably the most important, but also, Josh mentioned public relations. And I think that the thing to think about there is, we kind of have this notion that, particularly here in Britain, that lawyers, we have the law and the law's the law, and whoever wants a lawyer should have the right, should have access to a lawyer, and that's true to a certain extent. Obviously, if I'm the defendant of a crime in a criminal prosecution, of course I should have access to justice, access to a lawyer. But that kind of principle is extended quite far beyond that. And what you find, and you experience this as a journalist, day in, day out, and at the Bureau, it really is, week in, week out. lawyers serve to protect their clients' interests in any number of ways, including sort of threatening libel action, pursuing civil litigation, all sorts of things. And the problem we face here is that, strictly speaking, it's all very much okay. It's in line with the guidance provided by the solicitors, regulators. It's in line with the law, and the legal community, which actually includes the judges who sit at the top of this, are very much sort of okay with it. So I think sort of where I'm going with this is what's kind of required is a little bit of a rethink in terms of what are the rules that basically the ethical guidelines that govern all professional services. I mean, I'm just using lawyers as an example here, but really there needs to be far stricter regulation on this front. Sorry, I'm just referring back to my notes. Yeah, I think really I just wanted to raise that, sort of shine the light on that particular area, and I think it's a fascinating area to discuss and something we could get some questions about maybe.
Franz, thanks very much. It's actually a really good place to end this kind of opening part of the discussion, because I guess what you're talking about there is we need to think about an ecosystem. And I think historically, we've thought about the banks that are moving the money. Then we started to think about what, if you like, the narrow definition of enablers, which is a little bit where Katie started with kind of the traditional lawyers, accountants, and so on. And now we need to stand back and say, well, hang on a minute, what other tools are being used by these individuals? And so, yes, it's PR companies that Josh mentioned, many of us following closely what's happening to Catherine Belton and her publisher at the moment around her book, Putin's People. Interestingly, in the EU's AML package that was put forward as sort of the great remediation for Europe this summer, back in July, they also suggest that a new category of obliged entities should be created, which includes those companies that provide the golden visa services. We all know who we're talking about. But again, those organizations have an obligation. So we've kind of moved a long way away from just worrying about who's moving money from A to B. And I think that's perhaps something that we should explore a little bit. But we've got some great and helpful questions coming in. So I wanted to perhaps pick up on a first one, and it slightly touches on something that Franz was talking about. But Katie, I'll put it to you, because I think we can apply this, at least in the first instance, to lawyers. And the question is, how effective do you think professional codes of conduct are in combating enablers, or ensuring that enablers actually operate within the law? Or are we beyond professional codes of conduct?
I mean, I think they should be effective in terms of the scope of them. The professional standards or principles for lawyers in the UK are quite broad. They're quite they're principle driven. So I can't remember them now. I used to know them, but I can't remember them now. But they're quite broad. So any kind of unethical behaviour should fall within them. Again, it comes to the thing about it, regulating it and enforcing it, and the Solicitors Regulation Authority, again, just to kind of take this narrow example of lawyers in the UK, can use those. They are principles driven, so they are quite broad. So I think there's a role for them, and I think they should be able to play a role as part of that framework of preventing this. I think we have beyond that, we have the money laundering regulations that's more specific, but we have that extra layer.
Well, maybe I can just turn to Josh on this one, because in the US, of course, there is relatively little supervision and regulation of these enablers, as you pointed out. That would suggest that professional codes and the like, frankly, don't cut it.
They don't cut it. I mean, first of all, they're voluntary. Second of all, like the details of them tend to be quite inadequate. So the auction houses have these guidelines. They don't require asking the fundamental question, which is who is the beneficial owner? Who's the ultimate and who's on the other end of the chain? If your customer is a legal entity or representing someone else, there's this norm in the art market of privacy and secrecy, and doesn't require figuring that out. Let's talk about lawyers. The ABA has their voluntary guidance, which I discussed this on page 35 in my report, Regulating the Enablers. There's this whole backstory of how the ABA was in conflict with the FATF, and then they negotiated, they worked together, they agreed upon mutually agreed guidance. And then as soon as it was published, the ABA published their own separate voluntary guidance. The whole purpose of that was to prevent the FATF recommendations from becoming law. That worked. But then also they made some tweaks in their own voluntary version. I did like a compare of the Word document compare to see what words they added and subtracted, and they did things like adding some discussion to emphasize, okay, yes, the FATF, the guidance is to ask for the beneficial owner. However, do it in a risk-based way. And what risk-based means is it's discretionary. Essentially, you don't have to do it. That's how they explain to their members what risk-based means. And they said, really figuring out who the ultimate beneficial owner is, this is the part they added, could involve a lot of cost, time, and effort that may not be worth it. Okay, that's an opinion to be added. It's not even like called out as an opinion. I mean, there are other examples as well that instead of saying, that you should file suspicious activity reports, as the FATF does in their document, they say you may withdraw representation if you find out that your client is using you to commit crimes. So the voluntary don't work. Yeah.
Yes, and I could argue, Katie, I'll come back to you. You could argue that you've had a chance to prove that this works. It hasn't done, so now we have to come in with a hammer. But Katie, you gave me a friendly wave.
Yeah, just to say, I think that's why specific rules are more useful. Like in the UK, they brought in a specific rule about how you use client accounts, for example. And I think those kind of more specific rules are more useful than the perhaps in the broad brush approach that can be, a bit more.
Lawyers love a bit of specificity to get their teeth into. Franz, I'm going to come to you for the next one. Question here around getting a sense of, and this, I think we can probably unpack this a bit, but do we have a sense whether professional enablers are like dabbling in shady activity while doing mainly legitimate work? So it's kind of something that's done on the side, or are we actually talking here about a smaller subset of professionals who are dedicating themselves to kind of providing money laundering as a service? I suspect you've come across some examples of this in your work.
Yeah, I think that's a really good question. And I think the answer is you have a bit of both. You definitely have the enablers who specialize in sort of shady business, but there's a very large contingent that sort of bleeds into or is part of the sort of respected establishment. And I mean, don't forget sort of political enablers who sort of form part of this world as well. And, often they're sort of highly respected members of society. And certainly, coming back to lawyers or bankers, I mean, if you think about the 1MDB scandal and, the Goldman Sachs banker, Tim Leitner, I mean, he was a very respected banker. And I don't think all of his business was based on sort of dodgy stuff. And that's certainly what I've observed. And often it's just, it might be a particularly a profitable client and, asking these people to do certain things. And again, sometimes some of it actually seems like it's okay, because I don't know, often with a lot of lawyers, I have a lot of respect for the legal community, but a lot of lawyers are able to justify what they're doing because they look at it through strictly legalistic rather than through an ethical prism. So yeah, bit of both, basically.
That perhaps argues for getting the standards and so on in place, and perhaps those that are doing it on the side, perhaps that then gets squeezed out because they follow the standards, though, and that isolates those that are doing it as a sort of professional, offering it as a professional service. Moira, I wanted to come to you with a question on cryptocurrencies. We always have to talk about cryptocurrencies at some point in these discussions. Now, arguably, the cryptocurrency ecosystem, VASPs, as the FATF refers to them, are kind of one of the newest sort of enabling tools on the block. Yet the world is moving quite fast on trying to regulate or introduce regulations around that kind of type of enabler. So, do we think that we should be concerned about cryptocurrencies when we're talking about enabling mechanisms, or should we perhaps be putting all the crypto energy into other things like lawyers and trust and company service providers?
Yeah, I would say that when it comes to grand corruption, I can't think of any examples of where crypto was used. There are some large institutional investors who are investing in large stakes in crypto, and could there be some corrupt money there? I don't know, but I would say it's a low priority. But on the other hand, I think regulating VASPs is a huge priority, not for addressing corruption, but just addressing all kinds of other criminal activity. I wanted to go back to what Franz was saying earlier as well, if I may, and it relates to something that you've said too, Tom, in the past, where the UK is really good at on the legislative side, but lacking on the enforcement. The US has weaker legislation, but tougher enforcement. And when Franz mentioned the 1MDB case, I was reminded that Goldman Sachs was fined $3 billion for aiding and abetting the 1MDB scandal or corruption or fraud or whatever you wish to call it. That works. That has an impact. That acts as a huge disincentive for anyone who might want to, enable that kind of corruption in the future. Now, that's being targeted at the banking community, but maybe we can start targeting some of these other enablers with those kinds of sanctions. I really do think enforcement works.
Yeah, and I'll come back to Franz in a second, but I think there's a kind of halfway house in all of this, which is, we know obviously that in the banking sector, it hasn't just been fines that have been put in place, but it's, they have these, in the UK, we call them Section 166 orders, but essentially it's when the supervisor sends in, or a law firm, and says, you need to prove, or you need to audit, you put in an examiner, you need to prove that your systems are actually working. And I just wonder whether we're being forensic enough about the way in which we kind of go into these organizations and look at their standards and how effective they're being. Franz, you wanted to come back in.
Yeah, I just wanted to sort of riff off what Moira is saying. And I think in the last few years, the UK has sort of struggled with, well, maybe not just the last few years, but struggled with enforcement somewhat, and for many reasons. And, one of them being under-resourcing. But, one quite well-known example is the sort of unexplained wealth orders that we've all talked about a lot. And what often happens is that the enforcement agencies run into headwinds, and then the whole thing collapses. And just anecdotally, from speaking to people in enforcement, but also sort of lawyers in the defense community, what I think enforcement agencies are moving towards is more of a focus on sort of disruption, because actual criminal prosecution is quite a difficult thing to do. And which is interesting, and apparently is very effective. But the big problem with that, and unlike with the Goldman Sachs fine, quiet disruption has probably very, very little deterrent effect. So that's quite a big problem with that.
Okay, thanks for that. There was a kind of follow-up actually to the question asked earlier about whether we're talking about kind of money laundering as a service enablers, or whether it's something that people do kind of alongside their day job. And Katie, I might turn to you for this one, given your experience. And I think the question is, does the answer to that question, it's a bit of both, does the answer to that question vary depending on whether we're talking about money laundering in association with drugs trafficking, which is kind of perhaps hardcore criminality, and fudging the paperwork for a golden visa application, which perhaps seems a little bit less insidious? Do you think that we could make a difference there?
Yeah, I mean, we don't know the answer to that question. It's an interesting question that it would be useful to know more about. Specifically, what I would say is that it's probably, I would say, the more specialized the service, perhaps, the narrower the group, or the narrower the scope of the people involved in it. So, in thinking about drug trafficking, things like that, often the proceeds of drug trafficking are laundered through property, things like that, and so it can be just conveyancing that's done by high street solicitors, lawyers. So that kind of thing, conveyancing that's done on property that's bought through the proceeds of drug trafficking, is quite possibly done by small to medium-sized law firms. And so that can just be a case of bad due diligence, for example, across a whole range of different law firms alongside the legitimate business that they're doing. So it's perhaps the more specialized services, perhaps, that may involve a smaller kind of group of lawyers or law firms involved in that.
Okay, thanks for that. There's another question which, Josh, I might come to you on first, because you've been thinking about kind of who needs to be under this umbrella, which is question around casinos, but also actually interestingly online betting, which of course again I think is a known form of money laundering. I mean, where do we stand, first of all, in the US when it comes to regulation of casinos and online betting? Is that something that has already been covered, or is that still to come?
Casinos are covered, yes. Online, so I don't know exactly. It's a good question about online casinos, whether or not they're included within the FinCEN regulation around casinos. But I do know that whether or not the online casino per se is included, there is a whole ecosystem of money services businesses that cater to whether it's like phone scams, online casinos, pornography websites, these like internet and phone shady businesses that have their own special cash services and transmitters that are sometimes not in the country or don't have a physical presence. And so for one reason or another, they fall outside of FinCEN's rules. And so that was another recommendation of my report, which is that FinCEN conduct a review of that market and ways to shore up its money service businesses rules. Thanks.
Moira, I'm gonna throw the next one to you, which is pretty technical, so I'm sure you'll rise to the challenge. I'm just going to read the question. It's the easiest way to do it. Please comment on filling the gaps in the US CDD rule, customer due diligence rule, for entity types used by the enablers not currently covered. So I guess, how do we strengthen the way in which those that are required to respond, how do we strengthen the way that they respond?
Mm-hmm. I am actually going to hit that back into Josh's court, since he is the expert on legislative strategy.
That's nice of you to say, because I know, there's two different things, right? There's how do you cover the right entities, and then how do you cover the right professions, and not just with the CDD rule, but also more broadly making the professions establish anti-money laundering programs. And that's what the enablers research is about, if you do that broadly, they will also then have to, with time, comply with the CDD rule. And then there's entities. That covering all the right entities is really a job for the beneficial ownership registry to make sure that it's broad and does not include only companies, but also trusts and foundations. Trusts in particular, because given everything that we've learned this week about South Dakota, I also included a link in the chat to my blog about how to strongly implement beneficial ownership. And I did talk about the South Dakota, the expanding market there, and the difficulties with the way the Corporate Transparency Act is written, the statutory language, because there was resistance to it on the Republican side in Congress. They added language to say can only be entities that are set up by sending documentation to the state. And so for that reason, that was done essentially to make it very hard for Treasury to include trusts in the beneficial ownership registry. There's some ways they could do it by like deeming public notaries to be part of an office similar to the Secretary of State, but it would have to take some really aggressive implementation by Treasury.
Okay, we've got a couple of final questions, and actually one of them is a brilliant roundup question, which I will ask second. But the first one, Katie, I'll come to you, and I can feel the pain in the typing of the questioner, Duncan Hames from Transparency International, who says, when of all things, the Crown Estate is trading premium London real estate with ultimately the first family of Azerbaijan, do some enablers still struggle to understand which transactions they should be backing away from? Have a go at that one.
I mean, I guess so, yeah. I mean, you'd have to ask them whether they're still struggling to understand it, or whether, it's still too easy to kind of turn a blind eye to the types of transactions they should be backing away from. But yeah, there's enough information out there, surely, I would say now, and enough knowledge about this issue, surely, that people should understand the types of transactions that may be problematic.
I remember in my first morning of the JP Morgan training program all those years ago, we were told, if you only remember one thing from the next 6 months of training, it is, how would you feel when what you're doing appears on the front page of the newspaper? And I think that's a pretty good test to run your life by. But Franz, I want to maybe turn that question to you actually as well, because in your line of business, you obviously offer people the right to reply. And I'd be kind of curious, what are the kind of common replies that you get from people in this enabler world when you say to them, hey, we're going to run this story, this is what we found out, this is what we believe? What's your response?
Well, I mean, almost inevitably, the response includes some form of justification, and we ran all the necessary checks, but we didn't come across this, which you happen to find quite easily. I mean, I have to say, mostly they're very unconvincing, and. To an extent, the problem is that they know that there aren't any real consequences. Obviously, it's embarrassing to them, and there can be consequences from that perspective, from a reputational perspective. But they know they'll get away with it. So yeah, unfortunately, they're generally very unsatisfying, is all I can say. And often, again, they are coupled with a sort of legal letter. We reserve our rights. If you print anything erroneous, we may sue you.
Okay, I said there were two questions left, but actually Oliver Bullough has snuck in with a late race to the top of the leaderboard. So we're going to address that one before we come to my roundup question. So Oliver says, Timothy Noah has the policy proposal to abolish South Dakota, which may be taking things a bit far. But should the UK take more control of the overseas territories? I'm going to turn that round a bit because I have been loving the coverage about South Dakota in the US press over the last couple of days. It does seem, and in fact, Oliver's done loads of really great writing about the kind of various vagaries of different US states, but it does seem to me that there is this kind of astonishing Wild West, financial Wild West in these sorts of places. South Dakota, just the kind of the latest example. Bearing in mind the kind of federal nature of the United States, how does one try and get these states to play by rules that benefit the United States and the reputation of the United States, not just their state coffers, which I guess is why they offer the services they offer? Josh, maybe to you first.
Well, in a far less colorful, wonky economic term, it's a collective action problem, and so we need the federal government to avoid a race to the bottom, to have our own, as Oliver would say, internal money land within the United States. We need federal rules. That's what we're doing with beneficial ownership reform, and so we all knew about Delaware shell companies. Unfortunately, now these South Dakota. People should have read Oliver's piece on South Dakota a year or two ago when writing beneficial ownership. Maybe some did, and that's why they tried to get that excluded. But we're all also learning that we need federal solutions, not just on the entities, beneficial ownership, but on the professions, the enablers. We have to do it across the board. And I think the South Dakota reporting also shows that that has to also extend to supervision, because technically these trust companies in South Dakota were already subject to federal regulations, but then we deferred the supervision to the states, to South Dakota, and it doesn't happen.
Moira, do you have two fingers to add on that one? That's a shake of the head. That's a shake of the head.
No, I mean, I would when you say the Wild West, Nevada is also Wild West. And, we hope that the new Corporate Transparency Act will close some of these loopholes. But as Josh already mentioned, it doesn't cover a lot of things. It doesn't cover trusts. It doesn't cover shelf companies. It's really disheartening. I wish I could be more optimistic, but I'm not.
Yeah, there's certainly a long way to go. We haven't got much further to go on our discussion, but there is one final question. I wanted to do a quick round the panel on this one, super short answers, and that is, and in a way that ties together neatly with the task force on transatlantic response to illicit finance tariff that we're running at RUSI. And the question is, what does the panel think could be the most important joint initiatives that the US and UK could implement to indicate their seriousness in tackling illicit finance to the rest of the world? What messaging, and maybe if it's an enabler-focused message, that would be great. But let's go around in the original order. So Katie, I'll start with you.
Okay, that's a big question. I guess so that I kind of go back to the point I made that fundamentally this requires resources and political will and prioritization and cooperation. So something that brings together the four of those. I think joint political will between the two countries would be really useful. And I think at the moment, although it ebbs and flows, we're probably seeing more of the political will in the US at the moment.
Excellent. Josh.
I think the key point is that the US and the UK have to learn from each other, because we are each good at certain parts of it, right? On the US side, it's strong enforcement and often supervision. On the UK side, these issues that we're just catching up on, beneficial ownership and enablers, I mean, the rules still have issues, but the real problem is enforcement and supervision. So we need to learn from each other's strengths, and if we can both do both, if you will, we'll be in a really strong place. And these are the two deepest and biggest targets of dirty money in the world, our financial centers, and so it's key for us to lead on.
Very good. And the view from California?
I would say real estate. I think it would be it's again low-hanging fruit, and I feel like it's something that everyone can appreciate, and there's been so much bad press about this in London and all across the US, but mainly in New York and Miami. I would say if there could be some kind of joint effort or announcement or commitment, a joint commitment to at least make it more difficult for obfuscation of beneficial ownership when it comes to real estate. That would be, I think, an easy win.
And it's a particularly easy win in the UK because we have legislation waiting in the wings, which has been consistently, unfortunately, kicked down the road by the current government. But I think one of the things we all hope from the Pandora Papers is that it is impossible to ignore bringing forward that legislation now.
Yeah, and in the US, the equivalent action would be making the geographic targeting orders just apply nationwide and include commercial real estate.
Very good. And Franz, last word to you.
Yeah, I mean, I would maybe go for resourcing of enforcement and political backing of enforcement and transatlantic cooperation as well. If I could just add one small hopeful point relating to the Pandora Papers, which is obviously it shows how after the Panama Papers and the Paradise Papers, everything just carried on. But it also actually shows that, pressure does work, because the reason we were able to actually identify so many of the individuals in the Pandora Papers was that the beneficial owners were actually linked to the originally anonymous companies in the BVI. So, it does show that things can change fairly quickly.
Excellent. It's always good to end on an optimistic note. Well, look, thank you all very much, Katie, Josh, Moira, and Franz for joining us today. I'm not going to try and summarize what we've discussed, but actually one of the points that 2 points I've taken away from this is, firstly, there is an ecosystem, and we need to, you need a network to defeat a network, as was once said. And I think here we need to approach the ecosystem for what it is, and not just simply continue to focus on perhaps the easy targets, which have been for many years the banks. I think the other thing, and to me this is critical, and this is something that I've taken away from the discussion on the Pandora Papers this week, is if you don't admit a problem, if you don't admit there is a problem, you can't begin to resolve that problem. And I was struck by the words of the UK Chancellor of the Exchequer on Monday morning, who of course was going onto the airwaves to talk about the Conservative Party conference and his upcoming speech, who kind of went back on that. Well, the UK is the highest rated country when it comes to the FATF, nothing to see here, move along, please, ladies and gentlemen. And I think if you can't admit that there's a problem, then you're never going to fix the system. And I think that probably would certainly be the message that I would be wanting to deliver to listeners. So with all of that, thank you very much for joining. We do have a couple of further events coming up that I'd just like to bring to your attention. Next Friday, the 15th, we will be having a discussion about the role of the private sector in asset recovery. I think asset recovery remains an area of underperformance around the world. It's all very well freezing assets, but they aren't being returned whence they came as efficiently as they should do. And then in November, in the middle of November, we're delighted to welcome Casey Michel, US journalist, who's going to come and talk about his new book, American Kleptocracy, How the US Created the World's Greatest Money Laundering Scheme in History. So if you want to join either of those events, please visit the RUSI website. And just more generally, if you're interested in what we are up to, do please follow us on Twitter to keep abreast of our publications and other activities. We're at CFCS_RUSI. We have a mailing list that you can sign up for via the CFCS part of the RUSI website. And if you're into LinkedIn, of course, do please follow us at the Center for Financial Crime and Security Studies at RUSI. And if you're yet to discover our podcast series, The Suspicious Transaction Report, Season 4 will be back soon. More details on that to come. And then this event and many others, we turn into podcasts so you can listen on the go and catch up with shows you've missed. Just search for Financial Crime Insights and subscribe there too. So with that, thanks again to our panelists. Thank you all, our audience, for joining us today, for your support of our events as ever. And thank you, of course, to the RUSI events team for the production support today. So until next time, thank you all very much. Stay well and bye for now.